Hi, it's Marty Fogarty, and I'm going to walk through a husband and wife revocable living trust. This is the front page that we're looking at here, the cover page, and it's got the name of the trust and the date of the trust. There's the name and there's the date. Every trust is always identified by the name, the date, and the trustee. We'll get to the trustee on the second page here. The trust is divided into articles. Article 1 is just let's establish the trust. And we're basically saying, look, this is an agreement between trust maker and trustee. The trust maker is the person who creates the trust, creates the articles, creates all the rules. And the trustee is the person who is bound to follow all of the rules that the trust maker put in there. And it's okay if the trust maker is the same as the trustee. That's what we've got here. Today, on today's date, right? Husband and wife are the trust makers, right? And we are forming a contract with ourselves as trustees. Okay? That's all that's going on. We're going to create a trust and we're going to name it the sample name family trust. That's all that's happening here. Okay? We've established the trust. The trust has a formal name. This is it right here. And let's keep going down. The third party doesn't have to see the entire trust. They can just see a certification of trust. That means basically says our signatures are at the bottom, or an attorney's signature at the bottom saying, this trust does exist. It's the real thing. So therefore you can go ahead and open a bank account in it, etc. The trust is a vehicle. It owns property, but not until we put property in it. That's what section 103 is about. Now, the first section here says, hey, when we sign this agreement, we are conveying $10 and all of our personal property into the trust. So immediately the trust is valid. Immediately the trust owns property. During the lifetime of the trust, according to these rules, we can get all income and all principal. So anything we want to get from the trust, we can get. We are the trustees. We're the trust makers here. When we make the trust, it says basically we are able to preserve any powers that we want for ourselves. And basically in this trust, we're saying we can amend it, we can revoke it, we can restate it anytime we want. We love this trust because it is so flexible. You don't lose any power, any control over anything. We get to add property to the trust. We get to take property from the trust. We're responsible for making any kind of investment decisions in the trust. With regard to this trust, this is our family is going to be referred to in this trust. And so this section in Article 2 identifies who is the family here, okay? So we're going to say, here's our children. I'm married to each other. We've got these children. Boom, boom, boom. We identify them clearly throughout. Okay, that's really more just for reference. Then we go to Article 3. Article 3 talks about our trustees. Where are we here? All right. So our trustees, and we basically say, initially, we are the trustees. We, husband and wife, we already identified that before, that we are the trustees. And then we're saying if neither one of us can do this anymore, then the other one will continue to serve, right? The other shall continue to serve as if she were appointed from the beginning. I'm actually going to just switch this out to be a highlighter instead of a marker. I think that's going to work better. So if we cannot be the trustee, then the first successor trustee would be listed there. And then if that person couldn't do it, we would have a second successor trustee listed, okay? Now, this next section is what if someone resigns or is removed as a trustee? Well, we've got a process we follow. There's a whole set of rules that we follow here to remove someone as a trustee. Here, we're going to prohibit someone who's a special need beneficiary. This means we're doing this for that person's protection. if someone has a special need and they are a beneficiary of this trust, we don't want them to be also in charge of the trust, because that would eliminate some of the protections we just created for them. Now, what if someone needs to be removed as a trustee? That's what Section 305 is about. He said, this is how we're going to deal with the problem of replacing trustees, removing them. And it's pretty simple here. We can remove anyone at any time. Beneficiaries, they can remove them at any time as well. And we can always change these rules when necessary. But at this point, in this particular family, this makes sense. What if a trust is created and we don't have a trustee? What do we do then? Well, then basically we're saying that if we're incapacitated and we don't have a plan in place, then we can have a fiduciary, right? An attorney, accountant, corporate fiduciary. They can step in and serve as successor trustee. During our incapacitation, right? What if one of us is alive and not so well? What if we're incapacitated? Well, basically what happens is the trust exists for your benefit. So we're going to continue on protecting you as beneficiary, okay? We're going to allow the non-incapacitated spouse to carry on living and being in charge of the trust, and the incapacitated spouse is going to continue to get any kind of support they need from the trust. Let's go to Article 5. What happens when one of us passes away? Now you can see the trust is progressing here. It started out alive and well, then the last article was about alive and not so well. And now we're going, wait, now somebody's going to die. What happens now? Well, the first thing, when someone passes away, the trust becomes irrevocable. And the idea is we don't want to create a trust that can continually be changed. We want to honor my wishes. If I pass away, my wishes are now set. And basically what happens is we pay out any expenses or claims against me and my that I had occurred in my lifetime. We have to deal with any death taxes that might be there. That's all. At the time of death, what we do is we take kind of a snapshot and we identify what, if any, death taxes are due, what, if any, bills are there to be paid. And we kind of do a balance sheet and pay that off. And then whatever is left at that point, we're able to now go ahead and distribute. Now, if I pass and my wife survives me, then we look at my personal property, right? And we say, well, what did Marty want to have happen with that? And that's what this basically says, that I could either have a memorandum that lists my personal property, and this is where it goes. If I didn't have a memorandum, then the remaining property, this is the way it works. And basically it's going to go according to the way that my trust or my will says I want things to go. Now, anything that's left in my trust or my will, or any of, not my trust and my will, anything that's left in my estate that has not been distributed, anything that is owned by my trust at my death, this Article 7 basically says, at my passing, here's what happens. It goes here to child 1, here to child 2. You know, everybody gets 1 = 3 share, right? That's what Article 7 is about. Where does my stuff go? And then there's some direction here about how do we deal with these shares? How does that work? What are the protections? Article 8 has to do with retirement plans. Retirement plans are a world in and of themselves. If I pass away and I have a retirement plan, this article is going to give me a lot of great protections to the next generation, such as asset protection, divorce protection, creditor protection. So it's a long and complex article that really kicks into play at the time of passing, not really before. Article 9 says, hey, what if one of the beneficiaries when I pass away is underage or incapacitated? Well, that's what Article 9 talks about. This is what we're going to do for them. We're going to give them their money in a special, appropriate way. 10 talks about, okay, how do we administer this trust? What are the powers of the trustee? And we're going to say in this trust that basically the trustee, he's there to honor our wishes, and he's to distribute what we have to the people we want it to go to. We want him to not have to go to court, not have to post a bond. We don't want him to be subject of lawsuits if he's following our rules. He does have the right to compensation. My experience is that in most straightforward estates, the trustee doesn't want compensation. It's pretty straightforward if we've done a good job here. Then we've got language here that basically says the trustee is not, just because he's following our wish, he doesn't have the power to say where our stuff goes. He's going to, the power of appointment was mine. I have the power to appoint who owns my stuff. The trustee is just following that power of appointment, so it doesn't get counted against him per se. The trustee at some point may have to determine in this trust there is a certain amount of principal, and that principal gives off income. And in some cases, someone's going to have to make that decision. He's going to make that, or she's going to make that with the appropriate guidance of the law and attorney or CPA. Sometimes the trustee might want to hire an independent trustee. There may be something that he's going to want to do that. This article talks about what information is available to the beneficiaries. Sometimes we want them to have full information. Other times we may not want to, and that's what that article talks about. Our trustee can basically do what they need to do to follow our wishes. That might mean appointing a co-trustee or an agent, maybe splitting things up into separate trusts or ending certain trusts or merging trusts even. The idea is they know what our wishes are here. They will have to have a trust accounting. They will have to tell the beneficiaries, here's what we are doing, how we split things up. And they'll have to do that according to whatever schedule we establish there. They have the right to appoint a co-trustee or an independent co-trustee. Anyone who acts as a co-trustee takes on the ability to act as a full trustee to what degree of authority they've been given. Then we get to general provisions. Basically, spendthrift provision is that was giving us asset protection of the next generation. The no contest provision says, hey, dad loved me more, I should get more, I'm going to sue you to change the terms. If you do that, you get zero. Now we follow up with just basically definitions, of items and words that may have come up along the way here. Pretty straightforward stuff. At the very end, we're signing, we're notarizing, and that is all we need for a complete revocable living trust. Hope that helped. Let me know. Give me some feedback at mfogarty, Fogarty, @heartlandlawfirm.com. Thanks.